All right. Thank you, Amy. Welcome, everyone. Good afternoon. Thanks to you all for joining us. If you're one of the many people rushing to get your CLE done in time for the reporting deadline, you are most certainly in the right place. There's a lot of great CLEs that have been going on today. I know you all have been attending some of them. There's more tomorrow, so thanks for taking the time to join us for this one, which is going to be recent trends in copyright litigation. I'll start by introducing myself and my esteemed colleagues here. I'm Reid Mullen. I'm a partner at the firm, and with me today are Nate Brown and Julia Greenberg, associates here at the firm. And like most of the lawyers here, all three of us do a little bit of all different types of work, but one area of particular focus and candidly enjoyment for all of us is copyright litigation. So each of us is actively working on at least a couple of copyright cases right now at the moment. And some of the issues we're going to talk about today touch on issues that are, relevant to our cases and very near and dear to our hearts. We're obviously not going to talk in any detail about active cases, but these are important issues that are kind of bubbling up throughout the courts and pervade a whole bunch of different cases and issues. So overall, copyright litigation is very active right now. It's a very active area of the law. I think that's been true for the last probably decade or more. And I think that's especially true in computer software and other high-tech cases, particularly with respect to generative AI in the last several years. Now, given the close connection to the tech sector that we have here in the Bay Area, a lot of these cases are being litigated right in our backyard, which makes them extra interesting. You can go down and see really great advocates arguing summary judgment motions or trying these cases, addressing really novel, cutting-edge issues right here in our district. And of course, copyright has always had a close connection with the film and media industries. So there's a California connection there too, to what we're calling audiovisual works in this presentation. And that's really the slide you hear, or the slide you see right now is kind of covering the three areas that we're going to address today. We're going to take them in turn, but as you'll see, there's going to be sort of commonalities across several of these issues. We're going to talk about audiovisual works. We're going to talk a little bit about computer software, and then we're going to end by talking about artificial intelligence and the way that copyright issues play out in each of these three subject matter areas. So with that, I will turn it over to Julia, who's going to tell us a little more about some recent cases in the land of audiovisual works. Julia?
Thanks so much, Reid. Hi, everyone. So glad you're here to join us. I'm going to talk about copyright in the context of audiovisual works. So for the bulk of this section of the presentation, we're going to talk about one trial from last year that has some very interesting and relevant issues related to copyright practice. So we're going to focus on the Woodall v. Disney case that took place in the Central District of California. And let me start by giving some background about this case. So in Buck G. Woodall versus Walt Disney, screenwriter and animator Buck Woodall claimed that Disney's 2006 blockbuster animation feature, which I'm sure many of you have seen, it's a frequent film in my household, called Moana. He claimed that Moana infringed in a number of ways, but for our situation here is most relevant on copyright, infringed his 2011 screenplay called Bucky the Wave Warrior. Now, Bucky the Wave Warrior told the story about a teenage boy who was from New Mexico, moves to Kauai, learns how to surf, and then travels back in time, goes through a whirlpool portal, and goes on adventures with his friends. Along the way, he interacts with creatures from Hawaiian mythology, including a demigod that's tattooed, which is sort of starting to lean towards, potentially Maui, the character in Moana. Woodall alleged that he invested 15 years of time into developing a screenplay with characters, illustrations. He developed a theatrical trailer, and that he also spent around $500,000 developing this project. And just one other factor about this to know is that he claimed that he had pitched the Bucky screenplay, the concept, and then the actual project and materials to his sister-in-law's stepsister way back in 2003. And this woman her name is Jenny Merchik, and I'm going to name her because it will come back later. At the time in 2003, she was an assistant at a production company that was located in the same lot as Disney. And Woodall claimed that over the course of many years, all the way through until 2011, that they stayed in touch. He shared materials with her. She continued to be involved in the entertainment industry. And he claimed that she shared materials about Bucky, his screenplay, with Disney before they created Moana, and that it then led to the creation of Moana. So that's sort of Woodall's side of the story. Now, there were many claims at issue in the case. We're going to focus on copyright infringement because that's the sort of point of the CLE here. If we could go to the next slide, as I'm sure many of you know, to establish a successful claim of copyright infringement, a plaintiff needs to show two things: one, that they own the copyright, and two, that the defendant copied protective elements of the copyrighted work. And if we take a look at the Ninth Circuit's jury instruction for how you prove copying, there are two main aspects which are going to be the focus of our conversation. So let's take a look at the language here. The plaintiff can prove that the defendant copied from the work by proving by a preponderance of evidence that first, the defendant had access to the plaintiff's copyrighted work, and second, that there were substantial similarities between the defendant's work and the original element of the plaintiff's work. So we're going to talk first about substantial similarities just because it's more fun, and then we're going to talk about access. So there were a number of different ways, both at the summary judgment stage and at trial, that Woodall argued his Bucky creation was similar to the wonderful movie Moana. So, for example, he argued that both projects involved teenagers who defy their parents and go out and set on a dangerous voyage. Both were about saving a Polynesian island. Both, he argued, were about voyaging and being sort of navigating by star systems. There was sort of a demigod with tattoos. There's an adventure that leads to sort of disaster at sea and survival of a storm. And he also, those were sort of plot elements and characters that he said were substantially similar. He also pointed to specific examples of imagery that he argued was substantially similar. So let's take a look at a couple of those. If we go to so here's one example. I believe this is from the summary judgment briefing that shows a volcano goddess from Bucky's project, as well as Te Fiti, who's the goddess that's sort of an important feature in Moana. And if you look at the images side by side, they do seem to have some elements of similarity. Let's look at another example from summary judgment. So here you'll see that there's Bucky, the character, in a diaper on the beach looking out at the sea. And then you also have Moana as a baby at the beach looking out at the sea, both without parents. Let's take a look at one other example. You have another thing that Woodall pointed to is the location of these stories. And so the Bucky story took place in Honolulu Bay, which I believe is in Hawaii, and the Moana story takes place in the fictional island of Motuni, which is Moana's island. At least that's where she starts her adventure. So these were like the kinds of things that Woodall pointed to as being substantially similar between the two works. Disney's lawyers, of course, completely disagreed. They said not only were these not, necessarily all protected, but also there were just many, many differences between the two projects. Here are some examples. They said Bucky is white, whereas Moana is not. Bucky's from the mainland of the United States. Moana is not. She's indigenous to this fictional island, Motuni. Disney argued that Bucky is in the modern day, Moana is in the past. Bucky's an ordinary teen. Moana is sort of the future chiefess of her people, as well as a number of different differences in sort of the plot, the characters, the imagery, etc. So we'll get to what happened in summary judgment in a moment, but I want to talk about access first before we get to the summary judgment decision. So those were sort of the different similarities and differences for the substantial similarity assessment. In terms of access, you may recall from when we started talking about this example that Woodall argued that Disney had direct access to the Bucky project, that his sister-in-law's stepsister had given Disney access to some of the materials from his project. Disney denied this completely. They said that the creators of Moana never had access to Woodall's outlines or scripts, and they put into discovery millions of documents showing the production process of the Moana story, emails, developing the story, treatments of the story, things like that, that never mentioned Bucky at all. And a lot of those documents came into evidence at the trial. Okay, so before we get to the trial, let's talk briefly about what happened on summary judgment. You might think, based on what you've seen so far, okay, maybe, you might think, I guess if you weren't a lawyer, you may have judgment, but as a lawyer, you probably know that there are going to be factual disputes here between what I've told you. And so it was unlikely for the court to rule in Disney's favor on summary judgment. And that's exactly what happened. The court found there were too many fact disputes on substantial similarity, and there had been dueling expert reports on this topic. And the court also found that there were too many fact disputes as to access. And so the court said, if you want to move forward, you're going to need to do a jury trial. And that's exactly what happened. So in March of last year, there was a 2-week jury trial. It was in federal court in Los Angeles, highly contested, lots of witnesses and evidence. And after those 2 weeks, the 8-member jury only took 3 hours, actually less than 3 hours, to unanimously find that Disney did not have access to the 2011 screenplay or earlier treatments, and so there was no copyright infringement. They didn't reach the question of substantial similarity. They did not reach defenses because ultimately they found there was no access, so there cannot be copyright infringement. The kinds of evidence that they likely relied on based on the opening, the closing, and also sort of the evidence that was put in at trial are things like Disney said, as I mentioned before, there were millions of emails and other documents showing that Moana was developed separately. Marchik, the sister-in-law of Woodall, the stepsister of the sister-in-law of Woodall, testified that she had met with Woodall in the past as sort of a favor, but that she never actually passed along any materials to Disney. So we had sort of this key witness at trial who said, no, I never gave anything to Disney, which really cut against Woodall's case. And then finally, there was a dispute over an agreement that ultimately appeared to have been forged. Woodall put forward an agreement that he claimed Marchik signed that was sort of like a first look agreement. He claimed that Marchik had signed it back in 2003 and that it was her signature, but the Disney lawyers were able to show that actually she hadn't signed it. He could not prove that up. He couldn't authenticate it. And that actually it was likely that he had gotten someone else to sign the document, backdate it, and then put her name on it. So that really, really hurt Woodall's credibility and his lawyer's credibility at the jury trial. So it's not a huge surprise based on these facts that ultimately the jury found in Disney's favor. Now, this case is currently on appeal in the Ninth Circuit. We don't have a decision yet, and we'll have to see what happens there. But there are a couple of important takeaways for folks who are dealing with copyright cases in your practice. There are a couple of important takeaways. The first takeaway is that given the access question ended up being the jury's focus, there were a bunch of defenses that could have also been very successful that the jury just didn't reach here, and that could have been explored as part of opening or closing that may have affected the jury's perspective. And so if we take a look at the next slide, two things, one thing we've already talked about is sort of lack of substantial similarity, which certainly colored the way that this case was tried. And the second is Senafair. And Disney repeatedly said throughout the trial in both opening and closing that the kinds of things that Woodall was pointing to, the kinds of themes and characters and plot twists were things that could be found in many of Disney's movies and many of Disney's earlier movies like Little Mermaid or Aladdin or Hercules. They weren't the kinds of plot devices, scenes, and themes that are sort of protectable, but rather more Senafair that are not protectable. So if we skip ahead to the next slide, thank you so much, Nate. You'll see that there are a couple of key takeaways that we have from this jury trial. First, it's that it can be difficult to win. If you have sort of a close case, it can be difficult to win substantial similarity at summary judgment. And that's unfortunate because if a lot of you are representing defendants, or if you're working in-house and you have a Disney type client, you may want to try to get rid of these cases early on. But if the facts are sort of close, the court may be hesitant to decide on summary judgment. And second of all, When there's no evidence of direct copying, access is going to be really, really important. So shoring up evidence on both sides as related to access is going to matter for proving or defending against these claims. Now, I just told you that, you're unlikely to win on summary judgment. You're going to have a hard shot. That's not actually always the case. If we turn to the final slide in this section, there was also a very interesting Ninth Circuit opinion that came out late last year that says almost the exact opposite, which is that these kinds of claims should be dismissed on the pleadings. And so taken together, this is going to be a case-by-case assessment when you have the copyright claims. But what the Ninth Circuit said is we need to take a close look at works and see if there are more significant differences than similarities. If that's the case, then we may be able to decide substantial similarity on the pleadings. And the second thing that the Ninth Circuit said is that we need to actually, lawyers should take a close look at what kinds of devices, what kinds of things are actually being claimed as protectable. And folks need to make sure that it's not basic plot ideas like going on a journey with a demigod. That's maybe the basic plot idea and not something that's protectable, that's copyright protectable. So in the interest of time, I'm not going to go into the details of this case, but it's certainly one to take a look at. Biani v. Showtime, if you are in a situation where you have a copyright case that you think you may be able to get rid of on the pleadings, take a look at some of the very helpful holdings in Biani for your case. Thanks so much, and I'm going to pass it back to Reid, who's going to talk about copyright computer software.
Okay, thank you, Julia. Before I even dive into computer software, I'll mention two things that I think stand out to me about the Moana case. The first is the way that some of these copyright defenses work together in a case, particularly defenses like sans affaire and substantial similarity and access. You have an instance in Moana where there is arguably some facial similarities, and the fact finder may be left wondering, well, if you didn't have access to the plaintiff's work, how is it that these similarities came up? What is the logical explanation for that? And that's where sans affaire can do some work for you, that no, these are common elements of this type of story set in this place. And it can help to sort of, even if it's not a winning defense on its own, the mix of those defenses being in a case together can often be a very powerful tool for a defendant in a copyright case. The other thing I was going to mention, which is frankly just an aside, is that Moana is an amazing movie. And maybe we ought to discuss when we do this presentation next year, just doing a screening of the movie and see if we can get CLE credit for that. So we're going to task Amy with looking into that. But in all seriousness, now we turn to a slightly denser subject, which is copyright in computer software cases. And I like to begin this presentation with one of my favorite quotes from an old case from the 90s that is sort of a fair warning about the messiness of the fit of copyright to computer software. This is from a relatively famous concurrence from Judge Boudin in the First Circuit from a case called Lotus that we're actually going to discuss in a little bit of detail. And what Judge Boudin said is that applying copyright law to computer programs is like assembling a jigsaw puzzle whose pieces don't quite fit. We're going to see that quote come up in another very famous copyright case in a little bit. But first off, let's take a little bit of a look at Lotus in what Judge Boudin was dealing with and what that case was about. Lotus was a company who developed a spreadsheet program in the 90s called Lotus 123. Borland was a competitor of Lotus's who developed a similar spreadsheet program. And the main similarity between the two was in what was called the command hierarchy of the Lotus spreadsheet program. It was essentially the way that Lotus named and ordered and grouped the commands together that a user would use to operate its spreadsheet program. So commands like print or copy or save or edit were grouped in a certain ways in a pull-down menu, and the user became familiar with what those commands were, what they did, and where to find them within the context of the spreadsheet. And so that's what the overall case was about. One thing that it is decidedly not about was copying of computer code. Copying of computer code tends to be a relatively easy, or at least easier, copyright case than these type of non-literal computer elements that courts have really seemed to struggle with. So, like in any copyright case, in the software context, I feel like Lotus and others are a never-ending search for the analogy that fits. And because this case was decided in the 90s, the court in Lotus went with what was then current technology and compared it to a VCR, which makes sense. They said the Lotus menu command hierarchy is like the buttons that you use to control a video cassette recorder. Play might be grouped next to stop, and they're going to have those names. Rewind might be grouped next to fast forward, and they're going to have those names, and so on and so forth. And of course, the Lotus program was a little more elaborate than that, but that was the basic principle. And so the issue in the case is that type of ordering, that type of method of operation, copyrightable? And here's where we get to the law. Section 102B of the Copyright Act, which comes after Section 102A, where Section 102A essentially says any original work of authorship that is fixed in a tangible medium of expression is copyrightable. Then Section 102B says not so fast. Copyright protection does not apply to ideas, procedures, processes, systems, or methods of operation. And that was really the key issue in the Lotus case, and that issue has persisted in many software cases since Lotus. What is a method of operation, and how do we interpret and define that in the context of computer programs, which by their very nature are functional and people use them to accomplish things? So if we could look at the next slide, we will talk here just briefly about what Lotus actually held. Lotus gave a relatively straightforward, although potentially ambiguous, definition of what a method of operation was. And it said quite simply that it refers to the means by which a person operates something, whether it be a car, a food processor, or a computer, in this case, a spreadsheet program, or in the analogy, a VCR. The court said the fact that Lotus developers could have designed their spreadsheet program in a different way or given different names to the commands, instead of saying copy, you could use the word duplicate. And instead of grouping that with print, you could group it in another area of the spreadsheet. The Lotus court essentially said that doesn't matter. No matter what you do, you are still functionally creating a method of operating a computer program, and that is clearly not copyrightable. So now let's use our VCR, fast forward 25 years past Lotus. We now end up in a giant computer software case, the copyright case to end all copyright cases, or so we thought, Oracle versus Google. As Judge Alsop called it during the trial, it was the World Series of IP cases. Now, I called it Oracle versus Google. You might notice that my slide says the opposite, Google versus Oracle. Well, that's a difficult thing for me. I will say that I and other lawyers at our firm spent over a decade litigating the case, including through 2 different trial court decisions, where it will always be Oracle v. Google to me. Obviously, spoiler alert, the case ends up going to the Supreme Court much later on with Google as the petitioner. And so now most people simply know it as Google v. Oracle. But I know that most folks, or at least many of you, are probably familiar, at least at a high level, with this case, given that it happened right here in our backyard and that it was a relatively prominent press-worthy case. But let me just talk a little bit about what was going on in the case, and you'll see a connection to not only Lotus, but also to some of the other fair use issues that are going to arise and that Nate's going to talk about a little bit in the context of generative AI. So if we could go to the next slide. The case was about the Java language and the Java APIs. They were created and developed originally by Sun Microsystems here in the South Bay in the early 90s. Oracle bought Sun in 2009 and promptly sued Google a year later in 2010. And similar to Lotus, There was no real allegation in the case that computer code, or at least not what was called the implementing code, the stuff that actually does the work in a computer program, there was no allegation really that Google had copied any of that code. The allegation was that Google had copied what were called the Java APIs, or rather the declaring code that sort of defines what the APIs are. And this little diagram here is actually quite helpful. And I will tell you that you may be surprised to know that this was authored by Justice Breyer. He included this diagram as an appendix to the Supreme Court opinion. I think if you read the opinion, you can tell that Judge Justice Breyer very much enjoyed the technology and enjoyed digging into it. And I actually, a friend of mine was telling me that he recently heard Justice Breyer speak on a panel a while back, and he had said something along the lines of Oracle v. Google was one of his favorite cases. So I think that's noteworthy and great that he took such an interest in the technology, particularly as we were on the Google side, and we were, of course, happy with the result. But in any event, what he's drawing here is the API. And on the right, we see a description of what the API is, or the declaring code for the API. And it's essentially a way of labeling a prepackaged functionality in a computer program. And it's not the functionality itself. That's what we see the bottom right called implementing code. The API is really just the way that a programmer accesses that code and calls to it to use it in their program. So you could say that's relatively similar to Lotus 123 and the way that a user used the Lotus command hierarchy. Or, again, to harken back to our never-ending search for analogies, you could say that the Java API was similar to a file cabinet. And in fact, that's exactly what we did in the trial. The file cabinet was a demonstrative exhibit, I believe, in both trials, if I remember correctly. We used it to illustrate and to explain to the court and to the jury about what exactly this stuff was and why, in our view, it wasn't copyrightable, or if it was, our use of it was fair. And you see this analogy actually get a little bit of traction in the Supreme Court as well, where Justice Breyer, in addition to creating his nice little diagram there, actually tried out a couple of different analogies. He referenced the file cabinet. He referenced a QWERTY keyboard, where everybody gets familiar with that standard QWERTY layout. And it would obviously be a very big problem if somebody could copyright that layout and protect it from others using it in the future. So many of these software cases tend to be a search for analogies, then some can do more harm than good, but this one in particular got some traction for us. So if we can move forward, the procedural history of this case is very complicated. As I mentioned earlier, it lasts the better part of a decade. And so I don't have time to go into all of that, but I want to give you a high-level overview of kind of the way that the case developed. The first round, round one, back in 2010, the case was filed. In 2012, it was tried to a jury and to the court. After a jury trial, the trial court holds that the APIs were not protectable because they were a method of operation. That doesn't happen until a month or so after the trial. The jury during the trial is instructed that they ought to assume for their deliberations that the APIs are in fact copyrightable, and then they should weigh in on whether Google had infringed them and whether Google had proven its fair use defense. Ultimately, the jury hangs on the question of fair use. So we don't get a binding jury verdict on that issue. But as I mentioned, Judge Alsup, after the trial, finds that none of it mattered anyway because this stuff is non-copyrightable in the first place. Now, because the case started out with a patent in it, actually 7 different patents, if I remember correctly, even though we're in the Northern District, the case goes up on appeal to the Federal Circuit, not to the Ninth Circuit. The Ninth Circuit has to apply, or excuse me, the Federal Circuit has to apply Ninth Circuit law. But in doing so, they reach a result that reverses Judge Alsup on the copyrightability ruling, finds that, in fact, the APIs were copyrightable and remands for a jury trial on fair use because, of course, there is no verdict on that. We have a hung jury, so we need a new trial on fair use. If we can go to the next slide here, just want to highlight a couple things from the Federal Circuit's first ruling on this issue. Federal Circuit takes on both issues, particularly on copyrightability. It spends the vast majority of its time discussing that issue in the opinion, and in particular, explaining and distinguishing the Lotus case and the way that Lotus treated a method of operation. And what the court ultimately concludes is that a set of commands to instruct a computer to carry out desired options or operations may contain expression that is eligible for copyright protection. On fair use, the court finds there's a fact issue, and so we've got to remand for a new trial. So that's what we do. We go back in 2016. Now the only issue left to decide is fair use and potentially damages. Both sides agree to have the jury resolve the question of fair use. We have a 2-week trial in 2016, and this time we get a verdict. The jury finds fair use. Oracle files for JMAL of no fair use after the trial. The trial court denies it, and the case goes back up on appeal, this time only on the fair use issue. Now, we're going back to the Federal Circuit. We can go to the next slide. Mind you, the same Federal Circuit who 3 years earlier had held that there was a triable issue of fact for a jury to resolve on fair use, now says there is no fact issue left for the jury to resolve. Fair use is a mixed question of law and fact, and the ultimate question of fair use or no fair use is a legal question and gets de novo review. So reviewing the record, the court or the Federal Circuit finds no fair use as a matter of law and remands for a trial on damages. But that's not the end of it. Google files a cert petition, as we did after the first Federal Circuit decision on copyrightability. At that time, back in 2014, the court declined cert. This time, the court grants cert. And notably, the court grants cert on both issues, copyrightability and fair use. And I think there were many people in the industry who believed that this would be the definitive answer on copyrightability, Section 102B, and methods of operation. I should say, as an aside, the Lotus case was also taken to the Supreme Court. The Supreme Court granted cert in Lotus, but the Supreme Court at the time, Justice Stevens had to recuse, and the Supreme Court reached a 4-4 tie on the decision. So it was an affirmance with no opinion. And so this question had been lingering for many, many years about how to sort of treat computer programs and copyrightability issues. And there was a big belief that the Supreme Court would resolve this issue. Of course, the Supreme Court opinion ultimately does not. The court's opinion ends up only addressing fair use. Now, if we can, actually, we can go back to the last slide for just a second. I'll mention one other oddity, so to speak, of the way that this played out in the Supreme Court. The cert petition was granted in November of 2019. The case was set to be argued on March 24th, 2020, initially. Of course, in between, a little thing called COVID happened and everything shut down. The argument was canceled and was postponed to the next term and was going to be a Zoom argument. And given the 6-month or so postponement of the argument, in the interim, Justice Ginsburg passes away, and it's before Justice Barrett is appointed. So we are once again, just like Lotus, left in a position where there's at least a possibility of a 4-4 tie on this important question. Now, as it happens, spoiler alert, that's not actually what happened. We end up getting a 6-2 opinion from the Supreme Court, finding for Google, but on the question of fair use, not addressing the question of copyrightability. Now we can go to our next slide there, Nate. I'm highlighting here, it's a lot of text, but I want to emphasize that both of these questions were before the Supreme Court. And right at the outset of the opinion, the court said Essentially, given the rapidly changing technological, economic, and business-related circumstances, we believe we should not answer more than is necessary to resolve the parties' dispute. In other words, the court thought it was a little bit easier to resolve this case on fair use than to wade into the copyrightability issues. So that's what they do. They reverse the Federal Circuit and they find fair use as a matter of law. So let's go forward to the next slide. I'm just going to talk at a very high level about the fair use factors and how they sort of played out in the Supreme Court. It's a long read. Everybody should read it. It's an important case in the copyright world, particularly in computer software. But I'll highlight here the four fair use factors. I think Nate's going to discuss these a little bit later in the context of generative AI. But there are four statutory factors that courts look at: the purpose and character of the use, the nature of the work, the amount or substantiality of the portion used, and the effect of the use on the potential market for or value of the work. In the Federal Circuit had found that decisively factors 1 and 4 in particular weighed against fair use. The Supreme Court takes a look at the same record and reaches the opposite conclusion. It holds that every factor weighs towards fair use in the case. It finds that Google's use was transformative. Google had built something new and different and used these APIs for a different purpose. The declaring code, the nature of that type of work, was further than most copyright programs or most computer programs from the core of copyright and is therefore entitled to less protection in the fair use analysis. A very small percentage of the Java API code was actually used by Google. That's the third factor on the amount and substantiality. And the fourth is that Android did not harm the actual or potential markets for Java, and Google's use actually advanced the goals of copyright. So the Supreme Court finds that every single one of those factors weighs towards Google and does not address copyrightability. But the main point I want to make about Oracle v. Google, Lotus, and the way that some of these copyright issues tend to play out in computer software programs is that the nature of the technology matters. And even though the court did not address copyrightability, you can tell in reading the opinion that the nature of what these APIs were, how they were used, and how functional they were kind of pervades multiple steps of the Supreme Court's analysis, just the way that Sens Affair might do that same work in an audiovisual case. Those issues matter even when the defense is non-infringement or fair use. They are not purely copyrightability issues. We can go to the next slide here, and I'm going to do another callback to our fun quote from Lotus, because the Supreme Court, although again not deciding copyrightability, recognizes the same thing the Lotus court recognizes. This is a tough fit. And here they're actually quoting Judge Boudin's quote about the jigsaw puzzle. If we go on to the next slide, we'll see that there's a long portion of the Supreme Court's opinion where they describe what these APIs are and how they work. And after doing so, the court says this: these features mean that as part of a user interface, the declaring code is different from your average computer program. It's not your typical source code. It's not your typical implementing code. Yes, that might be copyrightable. That might even be highly creative. But the type of work we're dealing with here is different. Unlike many other programs, its use is inherently bound together with uncopyrightable ideas and new creative expression. And that's the key. The court is looking at, on the ground, how are these things actually used? And it very much matters to the fair use analysis in that case. And I think if we go on to the next slide, we can talk about just very briefly a couple of key takeaways for software copyright litigation post-Google. I think that the application of copyright law here is still a bit of a jigsaw puzzle. We're still seeing courts, the lower courts, work through the Google opinion and how to apply it given potential factual differences in each case. Certain aspects of computer programs may not be copyrightable, but it may be that fair use or some other defense is the better way to attack those issues, depending on, of course, the facts of your case. And that's what we're flagging here with the defense of fair use becomes even more important in these computer program type of cases. In two recent cases in particular, one of which we also worked on, the Synopsys v. Real Intent case. That was a case involving computer commands that were very similar to those in Oracle v. Google, and that case was resolved. The court found fair use on summary judgment. Similarly, in the Teradyne case, the court in the Central District of California found fair use on summary judgment, and the Ninth Circuit recently affirmed that decision on appeal. All of these are cases involving aspects of computer software, which is and will remain a hot button area of copyright law. So with that, I think I'm going to turn it over to Nate to talk about generative AI and a little bit more about some of the fair use issues we're seeing there.
Yes, I get to talk about generative AI, and it's an incredibly exciting and rapidly moving area of the law, and involving taking a lot of those fair use factors that Reid mentioned and applying them to a incredibly new technology. So many of you, I think, attended earlier presentations today about AI, and by now these products are everywhere. So I certainly don't need to give a big introduction about what generative AI is. But for purposes of this presentation today, we're going to be talking about large language models. And Julia and Reid as well have extensive experience working on copyright cases about artificial intelligence. So I welcome them to jump in with any additional color. So in these cases, fair use is a key defense, and it will ground our discussion today in the 20 minutes, 15 or 20 minutes that we have. And so I think before going into the factors, it's important to think about the purpose of copyright law, which is not just to protect ownership, but it's also to encourage innovation and promote the creation of new works with new expression and new meaning. And I want to make clear that fair use is not an exception or a loophole to copyright infringement. It is consistent with the foundational goals of copyright, and that the importance of promoting innovation. So the factors, Reid already went over them in brief, but I'll go into them in a little bit more depth. So 17 USC 107 lists 4 factors to consider in whether a given use is fair. The first is the purpose and character of the use. So is the use a substitute for the original work, or is it transformative? That's a very important concept for factor 1. And that means, has the material from the original work been transformed by adding new expression or meaning? Was value added to the original by creating new information, new aesthetics, new insights, or understandings? And this factor also takes into account whether such use is of a commercial nature or a nonprofit nature. The second factor is the nature of the copyrighted work. And you can get copyright protection on a lot of things, but the law is generally the most protective of creative works that are close to copyright's core. The third factor is the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And so courts here will ask, did you copy the entire work or just an excerpt? And courts will generally say that the less you use, the more it weighs towards fair use. And the final factor, factor 4, is the effect of the use upon the potential market for or value of the copyrighted work. And this factor involves looking at so-called market harm. Courts will analyze if the use is a market substitute for the copyrighted work. And you'll often see that courts will consider whether the harm alleged by the plaintiff is actual or likely, or whether it's hypothetical or speculative. And so weighing these factors is complex. It's complicated. It's not just about tallying up, one column of pro-fair use and one column of anti-fair use and seeing where the factors fall. You have to do a it requires a detailed analysis and involves weighing the factors against each other as well. And so one thing that I want to really stress here is that fair use is an affirmative defense. So it's the defendant's burden to raise and prove it. That said, plaintiffs and defendants often move for summary judgment on fair use. And in fact, rarely is fair use tried to a jury. It's almost always resolved at summary judgment. So I talked about weighing the factors, the fair use factors. For artificial intelligence cases, factors 1 and 4 are generally considered to be the most important. And those factors will focus on the transformative nature of generative AI tools, the market effects, if any, of those these AI companies' use of the asserted works. And it's worth mentioning that these cases are exploding all over the country. There are, by a recent count, 91 AI copyright suits and counting. It is a hot button area of the law. It has a major impact in our own home district, the Northern District of California, which has a plurality, if not a majority, of the cases that have been assembled here on this chart. And these cases are very active litigation with a lot of discovery, often very fast moving as well. And so courts are starting to issue orders that approach these, or opinions that approach the issue of fair use in artificial intelligence. And they're approaching these issues in different ways. So I'll talk about a couple of these cases. So the first case is Thomson Reuters v. Ross Intelligence. And this is a case out of the District of Delaware that has been going on for a long time. But the opinion that I'm going to talk about came out in February of 2025. So there are two key questions in that case. Well, actually, first, let me give you a little bit of background. So Ross is a competitor to Westlaw. I don't know if as in-house counsel you're using Westlaw a lot, but of course, I'm sure you remember it from law school or outside counsel sending you cases, printouts via of Westlaw or something like that. But so Rouse is a competitor to Westlaw. It made a legal research search engine that uses artificial intelligence. And to create this tool, it hired a third-party company that used contract attorneys to create compilations of legal questions and answers based off of Westlaw headnotes that in turn summarized judicial opinions. And Ross did not show these new headnotes to users, but it did use these headnotes and turn them into AI training data, essentially. And so the court held that Westlaw's headnotes were in fact copyrightable, and Ross's Intelligence's use of the headnotes was not a fair use, and it's worth going into why. So Ross's use, the court examined the four fair use factors, and the court held that Ross's use was commercial and not transformative. So both Ross and Thomson Reuters were using headnotes to create a legal research tool. So this goes to factor, the first factor. The court did admit the nature of the copyrighted work was not that creative, given that these were headnotes that were in turn summarizing judicial opinions, and they often included the language from the judicial opinion in the headnote itself. Then the court also noted that the output from Ross contained little sense of the original, But what the court really focused on, and I think is the key takeaway from this case, is that that these tools were market substitutes for each other. These were competitors in the marketplace. Ross was creating a legal tool, research tool that would compete with Westlaw. So the court finds that there's no fair use. What's especially interesting about this particular case is that 2 years earlier, the court had denied Thomson Reuters' motion for summary judgment on fair use. But then as trial approached, the judge essentially changed his mind, invited the parties to submit new briefing on fair use, and then granted Thomson Reuters' motion for summary judgment. So the next case that I want to talk about, the next cases that I want to talk about here are Bartz v. Anthropic and Kadrey v. Meta, which I'm sure many of you have read news articles about, if not read the opinions themselves. So these are cases that both are here in the Northern District of California. They have a lot of key similarities. They both were putative class actions that were brought by authors. Both were resolved mostly on summary judgment, or key issues were resolved on summary judgment. Both addressed similar fair use arguments from parties. And both opinions were published in June of 2025, 2 days apart, actually. So you kind of got the sense that maybe the judges were racing each other to get their big fair use of artificial intelligence opinion out. So what I don't have time to go through all of the details of these two cases, and I bet you all have familiarity with these cases already, or at least many of you do. But so I thought it might be most interesting to identify a couple areas where the Kadrey and Bartz opinions agree and where they disagree, because both of these cases, both judges, Judge Alsup in the case of Bartz v. Anthropic and Judge Chabria in the case of Kadrey v. Meta, they both wrote lengthy, detailed opinions that reached the same result, spoiler alert, finding fair use, but they do it in very, very different ways. So where they agree on the first factor of fair use. Judge Alsup says, and we're talking about training the use of copyrighted works to train large language models here. So both Judge Alsup says that the purpose and character of using copyrighted works to train LLMs to generate new text was quintessentially transformative. And Judge Chabria agrees, calls it highly transformative. So agreement on factor one. On factor four, they have some agreement where you see that they both, for purposes of their opinions, assume that training LLMs will result in an explosion of works that compete with the original works. But this is where they start to diverge a bit. Judge Alsup holds that the fact of an explosion of works as a result of training LLMs is not the kind of competitive or creative displacement that concerns the Copyright Act. Judge Chabria, on the other hand, says, well, I can only decide cases that are in front of me. And in this particular case, the 13 plaintiffs have presented no evidence about how the current or expected outputs from Meta's models would dilute the market for their own works. So they have these judges have very different views about this market dilution theory of harm, even though on the fourth factor, they both end up saying that it weighs in favor of fair use. And you even get them kind of in dialogue with each other, or at least Judge Chabria, whose opinion came out 2 days after Judge Alsup's, is directly commenting on Judge Alsup's opinion. Judge also, on the fourth factor, he says, author's complaint is no different than it would be if they complained that training school children to write well would result in an explosion of competing works. And Judge Tabria takes issue with this analogy. He says that using books to teach children to write is not remotely like using books to create a product that a single individual could employ to generate countless competing works. So, you know, these judges, as you can see, these opinions are in dialogue with each other, or these judges are commenting on other fair use opinions as they come out. And I would expect to see additional opinions in the very near future that comment in turn on Kadrey and comment on Bartz. So we are very close to the end of time. So I'm just going to skip the last slide here and just tell you a little bit about where, or the second to last slide, and tell you a little bit about where these cases stand now. So Thomson Reuters v. Ross, it is on appeal now. The judge in that case did something kind of very unusual, which is so after ruling on the summary judgment motion, he postponed the trial and allowed an interlocutory appeal up to the Third Circuit. He allowed Ross to take an appeal. And he said that, this is a direct quote from his opinion, "Though I am still confident in my February 2025 summary judgment opinion, the questions here are hard." And so you can see a lot of judges around the country really, you know, struggling with this issue, and it's a really meaty issue that they are digging into. Bartz v. Anthropic, it settled the core fair use issue regarding the use of the copyrighted materials for LLM training was decided, but there was another part of the case, and a class was certified on that issue. A trial date was set, and the case settled. And then Kadrey v. Meta, like Bartz, there was a core fair issue, the core fair use issue regarding the use of copyrighted materials for LLM training was decided on summary judgment. But another part of that case, unrelated to training, is still ongoing. So that's it for my slides. Thank you all very, very much. Reid, I'm happy to, if you want to jump in and say anything more about artificial intelligence, because I know you have worked extensively on these cases. Please do. But thank you all so much for your time, and I hope you enjoyed the CLE.
Well, maybe I'll just conclude by giving a tease for next year's CLE. As Nate suggests, as Nate says, these cases in the AI world are very, very active right now. And I have no doubt that when we do this presentation next year, there will be much, much more to talk about in this area.